Hello friends, in this video I would be discussing about a very important issue which came before the Honorable Apex Court just after the Indian independence in the year 1951, and the case in which this issue cropped up was a very famous case of Shankari Prasad versus Union of India. This case was decided in the year 1951, and the basic issue which cropped up in this case was what actually is the scope of amending power of the Indian Parliament. Whether the Indian Parliament has an absolute authority to amend each and every provision of the Constitution, or the amending power of the Parliament was subject to certain inherent restrictions. Now, now the question is how this issue came before the apex court. इसके लिए हम लोग थोड़ा बैकग्राउंड इसका देखेंगे। होता यूं है कि 1947 से पहले भारत एक ब्रिटिश कॉलोनी था और ब्रिटिशर्स ने जस्ट टू एडवांस देयर कॉलोनियल इंटरेस्ट इंट्रोड्यूस जमींदारी सिस्टम in various parts of India. Or as a result of zamindari system, a very rich class of people arose in the society, and the rich class was known as zamindars. They used to own huge tracts of land as a result of the Britishers' zamindari system. अब जब भारत आज़ाद हुआ 1947 में और 1950 में जब कॉन्स्टिट्यूशन फोर्स में आया, तो जैसा हम लोग जानते हैं कि प्रियम्बल इकोनॉमिक इक्वालिटी की बात करता है, तो इकोनॉमिक इक्वालिटी के लिए ये जमींदारी सिस्टम खत्म करना बहुत जरूरी था। इसीलिए जमींदारी एबोलिशन एक्ट पास किया डिफरेंट स्टेट लेजिस्लेचर ने। ये बिहार में पास हुआ, ये मध्य प्रदेश में पास हुआ और ये उत्तर प्रदेश में भी पास हुआ। अब ये जमींदारी एबोलिशन का जो कानून था, इट वाज चैलेंज्ड बाय द रिच जमींदार्स इन दोज स्टेट्स, एंड सम हाई कोर्ट्स upheld the validity of those laws, and some high courts declared those laws as void, violating the fundamental right of property. We all know that right to property used to be a fundamental right at that time. Now, the Patna High Court declared those zamindari abolition laws as null and void. And as a result of that, to protect those zamindari abolition laws, Indian Parliament amended the Indian Constitution and added Article 31A and Article 31B to protect those zamindari abolition laws. Now, in Shankari Prasad versus Union of India, which was decided in the year 1951, those amendments, that was the first amendment by which the Article 31A and 31B was added, was challenged before the Honorable Apex Court. Now, in this case, the main issue, there were two issues which were involved in this case. The first two issue was whether the first constitutional amendment 1951 passed by the parliament is valid or not. The second issue which was involved and which was very pivotal in deciding this case was whether the word law used under Article 13(2) also includes the law of the amendment of the Constitution of India. Now, the whole issue involved in this case was based on the clash between Article 368 of the Indian Constitution, which deals with amending power of the Indian Parliament, and Article 13(2) of the Indian Constitution, which states that the parliament cannot enact laws which takes away or abridges the fundamental rights. तो आप देखें ये शंकरी प्रसाद में आर्टिकल 368 और आर्टिकल 13(2) के बीच में क्लैश था. अब नाउ वी विल सी हाउ दिस क्लैश वाज रिजॉल्व्ड बाय द ऑनरेबल एपेक्स कोर्ट टू डिसाइड द शंकरी प्रसाद केस. नाउ वी विल सी इट. अब एक तरफ आर्टिकल 368 भाई पावर देता है पार्लियामेंट को कि तुम कॉन्स्टिट्यूशन को अमेंड कर सकते हो, एंड देर इज नो वर्ड्स ऑफ रिस्ट्रिक्शन. वो ये नहीं कहता है कि आप फंडामेंटल राइट्स नहीं अमेंड कर सकते हो. और एक तरफ आर्टिकल 13(2) है विच स्टेट्स दैट you cannot make laws, the parliament cannot make laws which takes away or abridges the fundamental rights. So to resolve this issue, the honorable apex court held that the word law which is used in article 13(2) is used in ordinary sense and it does not include constitutional amendments. Now this is very important reiteration by the honorable apex court at that time, because it has got far reaching implications with respect to the fundamental rights of the Indian citizen. If we say that amendments are laws within the meaning of article 13(2), then the Indian parliament cannot make amendments in the constitution to abrogate or abridge the fundamental rights. But if we conclude that the laws in the sense in article 13(2) does not include constitutional amendments, then parliament can amend the constitution even though those amendments abridges or takes away the fundamental rights of the Indian citizens. So in this case, the honorable apex court, the honorable supreme court, considered the absolute power of the parliament to amend the constitution, and the honorable apex court held that the parliament has got absolute power to amend each and every provision of the Indian Constitution, including part 3rd, which relates to fundamental rights. Now, to uphold this doctrine, the Honorable Apex Court held that the amendments are not laws within Article 13(2) of the Indian Constitution, and while passing amendments, while passing laws related to amendments, the parliament does not exercise its ordinary legislative power, rather it exercises its constituent power. On the other hand, while making ordinary laws within the meaning of Article 13(2) of the Indian Constitution, the Parliament uses its ordinary legislative power. So, although Parliament cannot make laws, ordinary laws, to abrogate and abridge the fundamental rights as per the mandate of Article 13(2) of the Indian Constitution, but the Parliament can make amendments in the Constitution which are not laws within the meaning of Article 13(2) of the Indian Constitution to abrogate and abridge the fundamental rights. So, in this case, the Honorable Apex Court narrowed down the scope of Article 13(2) of the Indian Constitution. Now, after this judgment, there was a little bit of criticism with respect to this judgment, because there was a murmuring in not in the legal field and in bar that the the apex court is the guardian of the fundamental rights of the Indian citizens. It would have protected the fundamental rights of the fundamental rights of the Indian citizens, and would have given such interpretation which would have enforced the fundamental rights, rather giving such interpretation which is giving absolute power to the Indian Parliament to abrogate and abridge the fundamental rights. So, as in 1967, other judgment of the Honorable Apex Court came, which drastically changed the situation of the Shankari Prasad case. The case was Golakhnath versus State of Punjab, which was decided by the Honorable Apex Court in the year 1967. And in this case, the Honorable Apex Court held that constitutional amendments are also laws within the meaning of Article 13(2) of the Indian Constitution. And although the Indian Parliament has the power to amend any provision of the Constitution, but not the provisions of Part 3, which relates to fundamental rights of the Indian Constitution. So, in this case, the Honorable Apex Court gave a very wide meaning to the law of mentioned in Article 13(2) of the Constitution, and it reiterated that even amendments are also laws within the meaning of Article 13(2) of the Indian Constitution. And the result was that this case really took away power from the Parliament to amend the provisions relating to Part 3 of the Indian Constitution. And then again, at last, in 24th April 1973, Keshavanand Bharti versus State of Kerala case was decided, and in that case, the Honorable Apex Court held that the Indian Parliament has a power to amend any provision of the Constitution except any provision, any chapter of the Indian Constitution except the basic structure. Now, doctrine of basic structure was evolved in this case only, and the Honorable Court held that basic structure are the fundamental principles on which the Indian Constitution is based. It is like a golden thread which travels from throughout the Constitution. It is embedded in throughout the Constitution. It is the soul of the Constitution, and the power of the Indian Parliament are limited by those basic structure doctrine. The Indian Parliament cannot amend those basic features of the Indian Constitution. So, after Keshavanand Bharti case, the final diktat of the Honorable Apex Court was the final conclusion of that judgment was that the basic features of the Indian Constitution cannot be amended by the Indian Parliament, even though it has power to amend each and every part of the Constitution except the basic features. Now, the question was, what actually is the basic feature? Then again, it said that it is the basic features, basic fundamental principle on which were the basis of the dreams of our constitution makers, and it is the basic policies on which our constitution based, and these basic features are beyond the amending power of the Indian constitution. Now the question again rose ki what actually are those basic features. The honorable apex court does never gave a exhaustive list, but it held that let the matter come before us and we will decide whether this is a basic feature or not. Some examples were given in this case as secularism, democracy. These were the and the but the honorable apex court never gave an exhaustive list in this case. So that was all regarding the issue which I was talking about, which I took some pain to explain to you all, the issue regarding the power of amendment of the Indian Parliament.